How to find this information? Plaintiff's brief in response to defendants' joint motions in limine, ECF number 415. Table of contents. Argument 1. Defendants' first motion in limine. Defendants ask the court to prohibit plaintiffs from establishing the standard of care for elders in the faith of Jehovah's Witnesses. As a starting point, this motion does not ask the court to rule that particular evidence or testimony is inadmissible. Instead, it asks the court to prohibit plaintiffs from proving an element of their negligence claims. This is not a proper motion in limine. Heller, 551F.3d at 1111. But even if it was a motion seeking exclusion of particular evidence or testimony, defendants fail to provide any reason why evidence of the standard of care would be irrelevant, immaterial, or unfairly prejudicial. It should be rejected on this basis alone. As set forth above, defendants' First Amendment argument is vague, unsupported, and fails to apply the applicable legal analysis. None of the cases cited support defendants' argument that plaintiffs should be prohibited from introducing evidence of the applicable standard of care. In Davis, the plaintiff, a church member, claimed negligent misrepresentation, fraud, and intentional infliction of emotional distress in the handling of her claim for injuries suffered in a fall. 852p.2d at 643. The plaintiff was challenging the church's decision to deny her a good standing report, temple recommend, and church work, church calling, to dissuade her from pursuing claims against the church. ID. The Supreme Court of Montana affirmed an order in limine, concluding that it would be impossible to evaluate the church's decision without an evaluation of the Mormon religion. ID at 649. The court further found there was no compelling state interest implicated in the plaintiff's claims that would permit such an evaluation. ID. Here, neither the court nor the jury is being called to resolve a dispute concerning plaintiff's relationship with the Jehovah's Witnesses. Instead, the jury will be asked to apply the same laws and standards of care that apply to all people and corporations in Montana. Plaintiffs are not seeking to establish a standard of care that applies to Jehovah's Witnesses only, they seek only to hold defendants to the neutrally applicable standards established by Montana law. If the manager of the local Kmart was sexually abusing those he managed, the same standard would apply, and the same types of evidence would be admissible. Further, unlike Davis, this case and the applicable standard of care pertain to the state's compelling interest in protecting children from sexual abuse. Thus, even if establishment of the standard of care involves aspects of the Jehovah's Witnesses' faith, defendants failed to put forth any evidence that its religious beliefs or practices would be impacted, and the compelling state interest permits the court and the jury to consider aspects of the Jehovah's Witnesses' religion which resulted in the hiding of child sexual abuse. The Watson and Presbyterian Church cases cited by defendants were church property disputes, and neither case stands for the proposition that plaintiffs should be prohibited from introducing evidence regarding the standard of care. While defendants' motion is titled as one about standard of care, they go on to claim plaintiffs are constitutionally prohibited from introducing evidence that contradicts what Jehovah's Witnesses say its religious doctrines, practices, and standards are. Defendants' brief. In support of joint motions in limine at 9, ECF number 416, hereinafter, DEFS. BR. But defendants have not specifically identified any such evidence they believe is inadmissible. Plaintiff's evidence of defendants' policies and procedures comes from defendants' own policy and procedure manuals. Defendants cite no basis for prohibiting plaintiffs from introducing evidence of their policies and procedures that is found in their own copyrighted and published manuals. Defendants' first motion in limine is actually a motion to prevent plaintiffs from proving an element of their negligence claim, and it lacks any legal support. 8. Defendants' eighth motion in limine. Defendants argue that Carla Klessen's deposition testimony should be excluded about things she allegedly overheard decades ago when she was a young child. DEFS. BR at 19. As a threshold matter, designations and objections to the use of deposition testimony at trial are governed by the court's pretrial procedure. Sked. Order at 7, ECF number 286. But in this motion, defendants only cite one page of deposition testimony they assert is inadmissible. Neither plaintiffs nor the court should be required to comb through an entire deposition transcript and guess what else defendants are referring to. That is why the court's pretrial procedure requires specific objections. As such, plaintiffs address the one page of Klessen's deposition that defendants cite to Q. Do you know if the elders of the Hardin congregation reported it to anyone? A. I know they were waiting for word back from New York for discipline. When I was 4, I remember them not knowing how they were going to take or handle it. I know that he had to wait for a week or whatever, for that was one of the things that he was upset about, you know. Because it hadn't been very long that they had made him an elder, and then had to take that away, so. But I know that they did get a hold of New York. Q. And how do you know that? A. Because I remember Mom talking about it, about them waiting to see how they were going to handle it. I remember Gunnar sitting down and telling us that this is, you know, we had to wait. Because for him to be an elder, it was something that he made a big deal of in the house, you know, all proud of it and everything. So when they took it, it was something that he made a point to let us girls know that, you know, he wasn't happy, he worked for a long time to become an elder, and that just didn't, that little bit of talking out of my mouth, that he lost that. So the guilt that he tried to put, it's just something that sticks out. Klessen's Dep. at 34:15, 35:15, ECF number 416-4. Defendants do not identify specifically what they contend is hearsay, but presumably, they mean Klessen's mother talking about them waiting to see how they were going to handle it and Gunnar Hain telling her, we had to wait, and he wasn't happy, he worked for a long time to become an elder, and that just didn't, that little bit of talking out of my mouth, that he lost that. As to her mother's statement, this would not be offered to prove the matter asserted, that is, that they waited to see how Gunnar's sexual child abuse would be handled. Rather, it would be asserted to prove defendants had notice of the abuse. It is thus not hearsay. Federal R. Avid. 801. As to Gunnar's statement, it too would not be asserted to prove that he was unhappy, that he worked a long time to become an elder, or that he lost his position. Rather, it would be asserted to prove defendant had notice of the abuse. It is thus not hearsay. Federal R. Avid. 801. Even if considered hearsay, Gunnar is deceased, and thus the exceptions in Rule 804 apply. Specifically, Gunnar's statement that he lost his position as elder is a statement against interest. Federal R. Avid. 804-3. Further, his statement that he was unhappy is a present-sense impression and thus admissible. Federal R. Avid. 803-1. Additionally, if the court agrees with plaintiffs and rules the elders in Hardin were defendants' agents, then Gunnar's statement is the admission of a party opponent and not hearsay. Federal R. Avid. 801-D-2. More broadly, Klessen's is expected to be called as a live witness at trial, and plaintiffs do not intend to offer her deposition testimony in lieu of live testimony. Rather than completely bar her testimony based on defendant's vague, unreasoned motion, the court should evaluate her testimony live at trial. Indeed, if defendants make specific objections at trial, it is very likely those objections can be overcome by establishing the circumstances and basis for Klessen's testimony as plaintiffs did above for the one page of testimony defendants cited to. In a footnote, defendants go on to argue that Klessen's testimony should be excluded because they allege it is unreliable. they cite nothing that would permit the court to exclude her testimony on that basis. The jury will ultimately decide whether to believe her and every other witness. See 9th Circle MJI 1.14, see also MPI 2D 1.02. Defendants can argue to the jury that Klessens is unreliable, but usurping the jury's role to determine credibility based on nothing but a legally unsupported footnote is clearly improper. See Conclusion. Only the most persuasive reasons justify handcuffing attorneys in the exercise of their advocacy within the bounds of propriety. Beagle v. Bassold, 65 Cal.2d 166, 181, 1966. Defendants have, in effect, requested this court rule in a vacuum without hearing or seeing plaintiff's evidence or argument. Thus, at best, defendant's motion is premature, overbroad, and inappropriate. Instead, objections should be made at trial if defendants feel that improper arguments are made. As it stands, however, defendant's motion is an improper attempt to limit plaintiff's case and trial strategy in this matter without basis in the law.